are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Good morning. Good morning.
Good morning.
Good morning. Good morning, Judge Berner and Judge Gibney. I apologize that I'm not there. I regret that I'm not there in person to sit with you. But I had some travel issues on yesterday. And also to counsel, I regret that I am not there in person, but we had some travel issues yesterday, as did, I think, counsel in our second case. So we will, I will be appearing remotely, and we are ready to begin. We will start with our first case, which is case number 25-1409, Environmental Hydrogeological Consultants versus North American Risk Services. And Mr. Armstrong?
Yes, Your Honor.
All right. Yes, sir. Thank you.
Thank you, Your Honor. May it please the court, my name is Lamar Armstrong. I'm counsel for the plaintiff appellant in this case, Environmental Hydrogeological Consultants, or EHC for short. Hog waste was freely flowing. The neighbors' properties and indeed their livelihoods were at stake. North Carolina Department of Water Quality was on the insured Legacy Biogas's case to do something about it then. So Legacy Biogas told EHC, the contractor, wait until Admiral, the insurance company, approves the coverage, approves the cleanup costs. Soon thereafter, the defendant, Mr. Scroggs, told Legacy Biogas, Admiral will pay the cleanup costs. That message was directly conveyed to EHC, and EHC proceeded to invest over $400,000 in cleanup costs over the next 3.5 weeks. Now, in this emergency situation, one person held the keys to the truth, and that was Mr. Scroggs. And he didn't have to act, he didn't have to say anything at all. This isn't, let me be clear, this is not about establishing or defining a standard of care for insurance adjusters. This is about the fact that Mr. Scroggs made a choice. He chose to speak. And when he chose to speak, he assumed a duty to do simply nothing but tell the truth. It's that simple. That's what Raritan, the North Carolina Supreme Court case that controls the claim here, says. And so we have this debate about duty because what we're really talking about is two different types of duties. There's the specific duty defined by the Raritan case in a negligent misrepresentation context, in a commercial context.
But Raritan is not a case in the context of an insurance adjuster speaking to a third party that's not a party to the contract. And it's never been applied, as far as I can see, by the North Carolina Supreme Court or really any court to apply to a situation like this where it's an adjuster speaking to a third party and not to a party to the contract. And so why should we, as a sitting in diversity as a court of appeals, essentially extend North Carolina law in ways that North Carolina itself has never extended it?
Good question, Judge Berner, for a couple of reasons. One, because the Raritan rule has been applied in the insurance professional context a couple of times. Our brief cites to the Hunter case, in which the rule was applied to a life insurance company, as well as the Middleton case, which was applied to a health insurance company. In the Middleton case, in particular, the North Carolina...
Were those adjuster cases?
No, those were insurance company cases, insurance professional cases.
Those are not independent adjusters?
No, sir. No, sir.
But Koch or Koch, however you say it was.
Koch was a case by the North Carolina Court of Appeals that, yes, it applied to insurance adjusters, but it never mentioned the Raritan rule. It didn't apply it one way or the other. And so the Middleton case cited in our brief is particularly noteworthy because the North Carolina Supreme Court in that case denied a petition for discretionary review. So it declined to take it up on review and say, clarify and say that no, the Raritan rule does not apply to insurance professionals. It was only meant to apply to the accounting field, which was the underlying facts of that case, but it declined to do that, and that's noteworthy. And so the different duties, and to Judge Gibney, to your question, the Coke case starts out in the procedural history and context of that case. It lists out all the different claims that the plaintiff brought, including negligent misrepresentation and including ordinary or simple negligence, among others. But the actual substantive body of that opinion doesn't mention, much less address, negligent misrepresentation.
And is the duty different as a matter of law under North Carolina law for negligent misrepresentation and negligence?
Yes, in fact, there are two different.
How does it differ?
It differs because negligent misrepresentation is defined in Raritan, as in defined in the North Carolina pattern jury instructions, is limited to, I mean, it's the same duty of care, but it's limited to the circumstances. It's limited to a commercial context where one speaks about knowledge or information that they know or have access to. And so when they choose to speak, they assume a limited duty to do something to inform themselves of the truth of what they're talking about, because they know in that context that someone's going to rely on what they have to say. And so the Coke case, is not a negligent misrepresentation case. It mentions the claim once in the procedural history, but then it doesn't address it, doesn't address Raritan. And in fact, all of the cases that it cites to in other jurisdictions on this point about duty are not negligent misrepresentation cases. They're all simple negligence cases.
What about Cedarbrook? Because in Cedarbrook, the North Carolina, oh, and I'm also mindful that my colleague Judge Benjamin is on Zoom, and I want to make sure she's able to get in. But I am concerned about Cedarbrook because it relies on Coke, and it is a case that is a subsequent and a very recent case of the Supreme Court of North Carolina. And so I am concerned that that case does adopt and incorporate Coke into it and suggest perhaps that we too must follow Coke here.
Yes, so Your Honor, Cedarbrook is concerned, as is Coke, about creating conflicting duties of care. And we fully agree that Mr. Scroggs, nobody should be put in a position to, on the one hand, have a contractual duty to act in the best interest of their client, the insurance company, but on the other hand, assume a duty of care that's somehow conflicting with the other duty. And so,
Let me ask you about that, because in reading Cedarbrook, it seems as if the North Carolina, in that case, that the North Carolina Supreme Court is saying, we're not going to get into creating conflicting duties of care. Not so much that there's this conflict, as you're saying, but they're basically saying we're not going to create. And then they also do, once again, cite Coke, this Coke case, which seems to square up pretty, it seems to square up with this case in terms of the adjuster and the negligent misrepresentation.
yeah, so Judge Benjamin, the Cedarbrook case addresses a situation where the plaintiff was an owner-operator of an adult home care facility. And it sued the North Carolina Department of Health and Human Services because it alleged that DHHS negligently inspected and took adverse licensure actions against it. So in other words, they were asserting that DHHS had a duty to act in the owner-operator's best interests. What the North Carolina Supreme Court held there is that no, the duty that DHHS has is to act in the best interests of the residents of the facilities, not the owners. But again, that goes back to what I was saying earlier, which is that here we're not alleging a duty to act. We're not saying that Mr. Scroggs had a duty to act in EHC's best interests as opposed to his client's best interests. He could have done nothing at all, but he chose to speak. And then once you choose to speak, that takes it out of the line of authority of Cedar Brook and Koch, where you're evaluating what must someone do to act in someone's best interests, and it brings it into the Raritan line of authority, where the choice has already been made. He spoke. Now that he's done that, understanding that people are going to rely on what he has to say, he's got to do so with reasonable care. So that's the difference. That's the distinction.
Let me ask you another question about that, because just, so I wanted to make sure I had a good understanding. So when you say on this whole reliance, once he decided to speak, because I think the other side's argument is that he spoke to, I think it's Balances is the way you pronounce the last name, Mr. and Mrs. But I do know that there was an invoice, that they sent the invoice, and then Scroggs responds to them regarding the invoice. Is that the reliance that the direct reliance that you're discussing, your claim is based on?
Yeah, it's two stages of reliance, Judge Benjamin. It's the first stage, which is once EHC was told, don't begin the work until the insurance company approves the claim, and then they were immediately told, insurance companies approve the claim, you may begin. So there's the reliance there on that initial representation. There's also the continuing reliance.
But that initial representation is between, my understanding is that initial representation is between the Balances and your client, not Scroggs. My understanding is Scroggs is speaking to communicating with the Mr. and Mrs. Balance, right?
The initial representation, correct. Yes, Judge.
And they're communicating with your client.
Yes.
But at some point, your client sends, so the argument there is that that's a conversation between the Balances and the adjuster. But then at some point, your client sends an invoice and does have a discussion, right?
Yes, so 4 times after the initial misrepresentation, EHC actually directly communicates with Mr. Scroggs and says, where's payment on our invoices? Until the very end, until after they were done doing the work and incurring the over $400,000 in costs, the response was, let me look into it for you. Let me look into payment. It may not be paid, it's still under investigation. And so there's a continuing reliance. There's the initial reliance, but there's also the continuing reliance as they continue to do the work and pump out the hog waste that, essentially, you're going to get paid, let me look into it. It's just a matter of when, not if.
And then, excuse me, go ahead. Those continuing statements, were those directly, just to follow on Judge Benjamin's questions, between the insurance adjuster Scroggs and your client, or were they essentially sort of via the company?
No, the former. They were all directly to EHC, my client.
So you sort of analogize this to, it's as if Mr. Scroggs was an auditor and prepared an audit report that he gave to his on behalf of his client, but it was of value to investors. And for that reason, he should be liable. Is that right?
Yes, he knew when he spoke that the insured Legacy Biogas would use that information to hire a contractor and to get the work done, and that's specifically pled in the complaint. Yes, Judge.
But
the other
doesn't he have conflicting interests? I mean, he's on the one hand, he's got Admiral's interest. On the other hand, he's got the Balance's interest. And on the third hand, he's got your client's interest, which are separate, all separate and go in separate ways.
Before he chose to speak, I would agree with that. After he chose to speak, if there's interest, they're all in alignment that he is to tell the truth or do what he can to tell the truth. Admiral would not.
That may not be the case with Admiral. I mean, Admiral may say, your interest to us is to deny coverage.
Well, I think Admiral would say that our interest is in having our agent speak the truth when they're speaking about coverage to anybody. I don't think any insurance company wants their agent out there misrepresenting facts about coverage, nor would anybody else. So I think the interests actually are in alignment once Mr. Scroggs chose to speak.
Their moral interests, but maybe not their fiscal interests.
Their legal interests, I would argue, Judge.
So back to the issue of there being an adjuster in this case, because the two cases that you pointed us to at the beginning of your argument, Middleton and Hunter, neither of them involved an adjuster. It was just a direct communication between the insurance company and the claimant. Is that right? So is it your argument here that it's sort of irrelevant that this is an adjuster, that he's acting as the agent, and therefore we should find that as the adjuster, he is essentially the same as the insurance company? Is that your argument?
It's irrelevant in the sense that the Raritan rule is a generally applicable rule. It's not a rule that was adopted only for the accounting field or for the insurance adjustment field or any other type of field. The rule says in any commercial context in which someone speaks, they have a duty and they speak in the course and scope of their employment or their agency, they have a duty to inform themselves of that which they're talking about.
Was Scroggs an agent of the balances?
Scroggs was an agent of the insurance company.
Okay, but not of the balances?
Correct.
So he couldn't have made a contract with your client?
That's correct. And if the duty is based upon relationship, that would matter. And so the defendants, they make this argument about, well, some of the cases, a duty is extended to an insured but not a non-insured, but that's only if the relationship's what gives rise to the duty, right? Because if you're an insured, you have a pre-existing contractual relationship with the insurance company and then at least arguably the insurance company's agent, whereas if you're a non-insured, you do not. But again, here we're not saying that the duty arises out of any pre-existing relationship. There was no pre-existing relationship between EHC and the defendants. The duty only arises once there's a decision to speak. I see that I'm out of time. With your permission, I'd like to save my remaining time for rebuttal.
All right, any other questions, Judge Berner, Judge Gibbons?
No.
All right, thank you, counsel.
Thank you.
All right, next we will hear from, is it Badar?
Bader, Your Honor, thank you.
Bader? Bader.
Good morning, and may it please the court. Stephen Bader here on behalf of the defendant appellees, North American Risk Services, and Randy Scroggs. This court should affirm dismissal for the defendants because EHC's sole claim for negligent misrepresentation fails under North Carolina law because an independent insurance adjuster does not owe a duty of care to a non-insured third-party claimant. That's the Court of Appeals holding in Koch. That holding was cited with approval by the North Carolina Supreme Court in Cedarbrook as an example of a case where North Carolina does not impose a duty of care because of potentially conflicting loyalties that a duty would impose on the defendant.
Let me ask you about this argument that he's making, that this case falls into Raritan because there's no initial duty, but once he voluntarily spoke with EHC, that the duty arises at that point.
I don't think that's correct for a couple of reasons. I think, first of all, that same sort of idea of a voluntary communication also occurred in the Koch decision. In Koch, there's direct communications between the independent insurance adjuster and the third-party claimant, and that fact didn't bring that case within to Raritan or really the restatement second of torts 552. I would point out that when this court looks at the briefing in Koch, if it's inclined to do so, that was one of the arguments that was made, and the North Carolina Court of Appeals did not find that availing. The second thing is the direct communications, and this is sort of the secondary argument that we made as to justifiable reliance, the direct communications between Mr. Scroggs and EHC don't start until June 7th. Now, the claim is apparently reported on June 1st. There is communications alleged between Mr. Scroggs and Legacy Biogas's principals that day, but the first communication between EHC and Mr. Scroggs is on June 7th where Mr. Scroggs is alleged to have said, "I've just obtained information on this recently, would be getting a report to Admiral, and then later follows that with a letter that says he's getting further direction from the carrier and would let EHC know when he hears from them." So that communication 7 days after the purported claim is not an acknowledgement of coverage. The idea, I guess, would be that by not disclaiming coverage, he somehow made an affirmative representation, but there would be no factual or legal support for that idea. Raritan certainly doesn't get to that, and Koch doesn't suggest that the mere fact that the communications are direct ultimately gives rise to a stated claim.
So could environmental hydrogeological consultants, they could have sued the Balances, or whatever their company was called, right?
Yes, and I believe that they have.
They have.
I think that case is pending, I believe.
And then can the Balances bring in, can they sue their insurance company and NARS?
They could, and that claim is also pending in the inverse. There is a declaratory judgment action pending on coverage as between those parties.
Okay. And under North Carolina law, could environmental hydrogeological sue Admiralty?
Sue Admiral Insurance?
Yeah.
I think in general, Your Honor, no. As a
Okay.
third-party claimant, that
They'd have to sue Balance, and then Balance could bring its insurance carrier in. Okay.
Right, in
So
some
what's the
form.
status of all that?
The federal declaratory, this is the best of my knowledge, so if I misspeak, it's only just in reviewing the file. The federal declaratory judgment action is pending before Judge Flanagan. That's the case as between Admiral and Legacy Biogas, with EHC joined in that action. And then there is a separate action that's pending in North Carolina State Court. I believe that is between EHC and then Legacy Biogas. Admiral may be a party to that as well, but I don't want to misspeak.
Okay, thank you.
But there are, in effect, 3 different lawsuits that are all stemming from this event. But as to this claim, and the claims against NARS and Scroggs, this is a dead ringer for what happened in Koch. I mean, in that instance, you had...
Your friend on the other side says that Koch is about negligence and not about negligent misrepresentation at base. And so that is one difference. And the other concern I have is that Koch is not a Supreme Court decision of the state, and it's a intermediate court decision, and that Raritan is, not only is it a decision of the North Carolina Supreme Court, it's been followed repeatedly by the North Carolina Supreme Court in many other contexts. And so, to me, it seems that that is the authority that we are bound to follow.
I'll try to address those different concerns in the order that I think I heard them. So, Koch involved claims for negligence, negligent misrepresentation, negligent failure to warn. There was also an Unfair and Deceptive Trade Practices Act claim. What the Koch court looked at was the idea of where does the duty arise. And it says that an independent insurance agent is hired and has contractual obligations with the carrier. That is who it's taking its directions from. And so what the court was concerned with was, and Judge Gibney pointed this out, it can't have loyalties to the carrier that hired it, as well as the insured that has a certain interest, and then an even more tenuous relationship with the claimant, which in this case would be EHC. In surveying how different states have handled it, the North Carolina Court of Appeals said that the majority rule is to find no duty of care in these scenarios, and even in the minority decisions where such a duty was found, that would be a duty to the insured and not to a third-party claimant.
In the context of negligence, but here we have a situation where there's a representation that there was an affirmative statement, and so it's not a claim for negligence, it's a claim for negligent misrepresentation. And so the duty would arise not out of the contract, but rather out of the statement, or at least that's the contention your friend on the other side is making.
Yes, Judge, but, and I I didn't articulate this very well the first time. I mean, there was a negligent misrepresentation claim in Koch, and the Court of Appeals said, we're still looking fundamentally at, is there a duty in this case? And the reason that there's not a duty isn't because the claim originates as opposed to something said, as opposed to something that was done or not done, but it arises because of the relationship between the parties and because of the potential for conflicting loyalties. A duty would not be recognized in that scenario, which is what the Supreme Court then cited with approval in Cedarbrook. But going
So
to,
he could just sign a contract with the cleanup company to say, go ahead and do it, Admiral will pay it, but he doesn't have any authority to do that. Is that what you're saying?
that Mr. Scroggs could do
Yeah.
that? I'm not sure I'm necessarily
Well, he
saying,
could send a letter to, maybe he did send a letter to Environmental Hydrological and said, go ahead with this, we'll take care of it. That just doesn't seem right.
he didn't do that, though, and that's.
Well, okay, he did it on the phone.
Well, not to them, not to EHC. He didn't have any.
Well, he had some contact with Mr., your opponent says he had some contact with the cleanup people.
The narrative as pleaded, Judge, is that on June 1st, this claim is reported by Legacy Biogas, really to the risk administrator, then to Mr. Scroggs. The allegation is Mr. Scroggs that day has a phone conversation with Deborah Balance, who's one of the principals of Legacy Biogas. After that conversation, then Todd Balance, the other principal, calls EHC and says Admiral's going to cover this. There's no communications on that date between EHC and Mr. Scroggs.
Well, later was there?
The first communication is on June 7th, 7 days later, at which point, according to the complaint, they call Scroggs, and what Mr. Scroggs says is he just obtained information recently on this, and he would be reporting to Admiral. He then is alleged to have followed that up with a letter that says he's getting further direction from the carrier and would let EHC know as soon as he heard from the carrier. Now, now that's not a representation as to coverage at all. And then the next communication would be, well, there's an allegation that 8 days.
The problem is that when it all came up, they got hog slop going all over the hillside, and, you know, the environmental authorities are all over the balances to clean it up, and this guy says, yeah, we'll cover it. So they go and hire somebody. That just doesn't seem right to me, then to be able to go back on that.
Let me address that squarely just to make sure that my argument is at least clean in my own head, that would really get to the alternate argument that the district court did not get to, which is that to plead negligent misrepresentation, the plaintiff has to show justifiable reliance. And that doesn't exist here in two forms. First of all, there's no allegation that they relied on anything directly that they heard from Mr. Scroggs about coverage. I won't repeat the narrative that I just went through in the complaint, but there is no allegation anywhere in this complaint that Mr. Scroggs made a representation to EHC that this claim was covered. The allegation to the contrary is that the representations he is making directly to them are that he is reporting to the carrier, getting information, and that he'll follow up when he hears. I heard my friend say that Mr. Scroggs, held the keys or something to that effect, and I would disagree with that. There is nothing that prevents EHC in the reasonable reliance aspect of justifiable reliance to simply asking Mr. Scroggs for a commitment as to coverage before it undertakes any work. This is a sophisticated business entity. They understood the nature of working with third-party insurance carriers, and they could have asked for something to that effect, and that would be part of the reasonable reliance to pursue a negligent misrepresentation claim. Had they had that, perhaps this case is different. There's still duty issues, but at least they would be able to argue that. As it stands, really what they're saying is we have a third-hand comment from a principal of this insured committing the carrier to coverage via a statement made by an independent insurance adjuster. That is far beyond the scope of the type of liability that the North Carolina Supreme Court said may attach in Raritan River Steel. And to get back to Judge Berner's sort of question about how the Supreme Court, or really North Carolina courts in general, have applied Raritan River Steel since its decision, they have not applied that section of the restatement of torts to impose liability in scenarios where you may have these potentials for divided loyalty. Just looking at the 4 cases that my friend cites in their reply brief, some of which have been discussed, Middleton versus Russell Group, that was a plaintiff suing their former employer and a health insurer about representations that were made about health insurance coverage. There was no independent adjuster or anybody with potentially divided loyalties involved in that case. Hunter versus Guardian Life Insurance, effectively the same posture. The other 2 cases, Sanford and Schaffner Industries, are both decided before Raritan. Neither cite the restatement second of torts, section 552, and neither involve scenarios where there could be the potential for divided loyalties.
But what section 552 talks about is, and I have it in front of me, where one in the course of his business, professional employment, or in any other transaction in which he has a pecuniary interest, I think it's fair to say that your client is a professional and had an interest in this transaction, supplies false information for the guidance of others in their business transactions, is subject to the liability for pecuniary loss caused by them by justifiable reliance upon the information if he fails to exercise reasonable care or competence in obtaining or communicating the information. I think we're at a motion to dismiss stage, and that seems, based on the facts alleged in the complaint, to be exactly what is being alleged.
Well, Koch was also decided at the motion to dismiss phase, and again, what the
But again, the North Carolina Supreme Court adopted section 552 of the restatement of torts, which is what I just read from.
I agree with that, but just because that has been adopted doesn't necessarily mean that it applies to any and all claims that are alleged. And what the North Carolina Court of Appeals said in Koch is that doesn't state a claim because there is an absence of duty because of the conflicting loyalties. And when we go back to the Raritan decision, that issue that the Supreme Court flagged in that case was the scope of an accountant's liability for others apparently relying on their work product. And the North Carolina Supreme Court says there's 4 different approaches that we may pick from to decide how to judge liability in a potential case like this. And the Supreme Court decided that Section 552 was sort of the best balancing test because what it did was it would hold accountants potentially liable when they know or have reason to know that other persons may rely on their work product, but not necessarily in situations where what they say is being repeated to others and others. And the court said—
Well, I think the allegation here isn't about what's being repeated to others. I think the allegation here is about the direct statements that were made.
Well, I disagree with that, Judge Berner, because the only allegation here about coverage is that Mr. Scroggs made a statement about coverage to Legacy Biogas, to one principal of Legacy Biogas, a verbal statement on the phone, and that verbal statement on the phone was apparently repeated from one principal of Legacy Biogas to the other, who then repeated that representation in different form than to EHC. Mr. Scroggs has never alleged—
What about the June 8th letter? What about the June 8th letter?
The June 8th letter did not go to EHC. That June 8th letter
No,
was—
but to the balances. The letter went to the balances and said that there's coverage.
Well, I don't think it quite went that far. I think what it referred to is what is available under the insurance coverage, or under the insurance policy. But I think more important for purposes of this case, that letter was not sent to EHC. That was a letter from Mr. Scroggs strictly to the balances. There's no allegation that that letter was sent to EHC, that was something that they relied upon, or any allegation that in following up with Mr. Scroggs about the status of the claim, that was something that they were following up on or asking about. Again, their communications with Mr. Scroggs that they've pleaded and alleged is that they asked him for follow-ups, and Mr. Scroggs says, I'm getting information, I'm reporting it to the carrier, and I will report back when I am able to. And
Well, one last question, but doesn't, after, this June 8th letter to the balances, that's when they go and say to EHC, hey, it's gonna be covered?
I don't believe that's the correct sequence of events. I think on June 1st, there's this literal and metaphorical game of telephone between Mr. Scroggs and Deborah Balance. Deborah Balance then talks to Todd Balance then talks to EHC, and Todd says to EHC, Admiral's going to cover the claim. That there's no pleaded allegations then that June 8th letter is sent anywhere. Well, that, I guess, to be more accurate, the Legacy Biogas sends that to EHC, or that EHC is somehow relying on that letter. The allegations subsequent to June 8th are that they have conversations with Mr. Scroggs where they are asking about the status of the claim, and he is reporting that he is getting information to Admiral and will report back when he is able. And that again, really squares with the idea of what the North Carolina Court of Appeals held in Koch, and what the Supreme Court addressed in, or what North Carolina Supreme Court cited with approval, rather, in Cedarbrook, which is there are just certain scenarios where, because an individual is going to have conflicting loyalties, the law does not impose a duty of care. Judge Gibney has identified various scenarios or recourse where this coverage issue could be sorted out. But a scenario like this really almost invites abuse, where you could have, a third-party claimant say, well, I talked to the person who owes me money, and they told me that they talked to an independent insurance adjuster, and the independent insurance adjuster said that the carrier was going to cover that. And just by virtue of those second and third-hand comments, you now have a claim for negligent misrepresentation. Koch rejects that. The North Carolina Supreme Court recognized that's problematic in Cedarbrook, and that's certainly far beyond what's contemplated by Raritan, where a third party is actually looking at somebody else's work product and relying on that direct representation. No such communications occurred in this case. The best they could say was that they were relying on Mr. Scroggs' apparent silence as to coverage as an affirmation that coverage existed.
So I know that the time is almost up, but I do have another question. Judge Benjamin, may I ask one more question?
Yes.
Thanks. So if this was a case brought by EHC for negligent misrepresentation against your client, based on the statements that were made by your client directly to EHC, would we be in a different, to Legacy Biogas, would this be in a different posture? Because there too, it seems to me, there would be conflicting loyalties. In other words, Legacy Biogas and the Admiral Insurance also potentially have conflicting loyalties. So why wouldn't we then say that there would be no negligent misrepresentation claim in that situation? And there it seems there would absolutely be a negligent misrepresentation claim.
I want to make sure I'm helpful in answering
Yeah.
your question, Judge. I'm not sure I totally tracked with the hypothetical.
Okay, so the hypothetical is, if this was a case not by EHC against your client, but rather by
Legacy Biogas.
Legacy Biogas against your client, where there is no question that the letter was written and there were statements saying that coverage would be, that the contract would be covered. Would there then also be conflicting loyalties under Koch, in your mind?
Potentially. Judge Flanagan, in another case that's cited in the briefing called Duck Village, said that in that scenario, despite the potential for divided loyalties, a claim could potentially stand as between the insured and the independent adjuster hired by the insured's first-party carrier to deal with the case. That is, of course, procedurally distinct here in a couple ways. It's not a first-party claim, it's a third-party claim, and the claimant bringing the case here, EHC, certainly has adverse interests.
So it's procedurally different, but there's also a divided loyalty there. So divided loyalty doesn't necessarily defeat a claim of negligent misrepresentation.
I'm not sure I necessarily, or rather I should say the North Carolina law necessarily agrees with that proposition. I think that what the court recognizes that independent insurance adjusters occupy a very unique space with who they are hired by, who they report to and are obligated to act in their best interests, and the various players that can come into place in different insurance disputes. Third-party insurance cases are going to be different from first-party insurance cases as far as the duties that insurers may have to the different players in that case. And so I don't think it's necessarily that narrow of a holding so much as a fact-specific holding as to what an IA does in a situation like this. And so because North Carolina law does not recognize a duty and because the plaintiffs have not pleaded justifiable reliance under Raritan Steele, we would ask this court to affirm. Thank you.
May I ask a question?
Yes, sir.
So let's just take it in a slightly different context. Suppose I was trying to sell my house to you, and I had inherited it from my distant uncle, and I didn't know whether I had clear title to it. So I asked a lawyer to go do a title search on it, and the lawyer hired a title company to do that. And the title company said to me, John, your title is clear, and I then told that to you. Could you sue the title insurance company over that?
I think that claim would fail under Arneson Rivers Edge as well as Hernandez versus Caldwell Banker, both of which rely on Raritan Steele. As I understand Your Honor's hypothetical, for the fundamental reason that I am not looking at a title opinion and making my decisions based on that title opinion. I am taking it secondhand from what you, the seller of the house, tells me.
Well, what if the title insurance company gave it directly to you? Then would it be a Raritan claim?
It would be more in line with Raritan, but
Okay.
again, to be clear with what's pleaded here, that's not
All
alleged.
right, thank you.
Okay, thank you.
Thank you. Yes, sir, Mr. Bentley.
Judge Gibney, I want to
I'm sorry, Mr. Armstrong.
I'm sorry. Judge Gibney, I want to go back to that hypothetical. The answer is yes, there would be a claim, and the reason is because it's the same information that's passed along from the title company to you that you would then turn around and pass along to the buyer, the potential buyer. So the direct standard that's articulated in Raritan in the restatement second is not direct reliance from the source of the information, as we say in Eastern North Carolina, directly from the horse's mouth. Rather, it's the same information. It's direct reliance on the same information. So there is no claim for negligent misrepresentation if title insurance company says, yes, good title, and then you turn around and say something modified or different than that, because at that point, it's not the same information. But if it's the same information, it can be conveyed through an intermediary and still be a negligent misrepresentation, and that's exactly what the Raritan rule says. To wrap up this discussion on duty, before I move on to the alternative arguments about reliance, if the defendants are correct, there's an element of common sense to this. If the defendants are correct in their analysis, then insurance adjusters in North Carolina can say whatever they want and do whatever they want with anyone other than the insurance company with impunity, without any consequence, without any responsibility for any of the collateral damage caused along the way.
Well, let me ask you about, and I guess this is a follow-up to Judge Gibney's question. Why is it that counsel would state that your relief would be in a suit against or a claim against the balances or against legacy? Why is that not the case? Basically, that you would be able to sue Legacy. I assume Legacy could sue NARS or Admiral. And why is that? I'm just interested to see your response to that argument.
Well, if I understand your question correctly, Judge Benjamin, any suit between EHC and Legacy Biogas would be a suit for breach of contract. It wouldn't be a suit for negligence because we have this thing called the economic loss rule. But that's different because here EHC doesn't have a contractual relationship with the defendants. That's why it's a negligence theory. Did I answer Your Honor's question?
Yeah, but I think what counsel's argument was earlier was that you do have recourse. Your recourse would be against Legacy.
And I would counter, Your Honor, that there is nothing under the law that limits my client to suing Legacy Biogas for breach of contract or Admiral Insurance for that matter, if there were a basis for relief there. Under Raritan, as pled, they have a claim against the defendants. Whether or not they have a claim against anybody else is irrelevant, I would submit. And so,
Are the balances still a going entity?
I think the complaint pled that they went bankrupt.
Okay.
So yes, we're not just engaging in an academic
Yeah.
debate here. There's real life consequences.
And just back to the statements that were made by Mr. Scruggs to your client, is it true that, I think what your friend on the other side says is there was never an affirmative statement that the work would be covered? There were affirmative statements to the, essentially ignoring the fact that work was ongoing. There was a failure to say this may or may not be covered. But that there was never an actual affirmative statement made by Mr. Scruggs to your client that their work would be covered by Admiral Insurance. Is that right? That there is no affirmative statement that could be the basis of a negligent misrepresentation?
Well, the direct statement, Admiral will pay the cleanup costs, was made through Legacy Biogas, but understanding that context, when then they have subsequent conversations which are direct, which says, let me check on payment, there's context with those statements, right? We don't have to reaffirm that coverage is going to be made. That's already been established, and now we all understand that, which is why we're saying, let me follow up on payment. So the context of it all is what you know, and again, it doesn't have to be a statement directly from the source under the Raritan rule. As for reliance, really quick, so it's an element of common sense here. Complaint does allege actual reliance. It does allege direct reliance on the same information, not the same source. And these folks, upon that information, directly rely by being out there 24 hours a day, 2 days, and then another week and a half. Your Honors, may I finish my statement before we finish?
Yes.
And so they relied on the initial representation of coverage and the subsequent representations tied to that initial representation to pump hog waste. And it's not an academic debate. There were with the boots on the ground, what they were told, they had no time to go knock on corporate headquarters at Admiral Insurance to find out or get a written coverage opinion or whatever. They had to act on the information that they were given at the time, and Mr. Scroggs understood that. Thank you, Your Honors.
All right, any other questions, Judge Berner, Judge Gibney?
No.
All right, thank you.
Thank you, Judge.
At this time, and once again, I apologize that I'm not there to walk down and step down and shake your hands, but at this time, Judge Berner and Judge Gibney will step down and greet you. Council is appearing remote. Also, first we have Mr. Bentley.
Good morning, Your Honor.
Mr. Forbes, just so we'll have a sound check. Mr. Forbes, can everyone hear?
Good morning, Your Honor.
All right, and we can hear you. All right, first we'll hear from Mr. Bentley, and then we'll hear from Mr. Forbes.
Good morning, Your Honors, and may it please the court. Michael Bentley on behalf of the appellant, Wexford Health Sources, Inc. With me on the briefs and also at virtual counsel table, although off of your screen, is my colleague Garner Baines. Your Honors, the district court certified 2 nationwide prisoner classes seeking damages and injunctive relief on the theory that the Constitution requires a particular intervention called MOUD for opioid use disorder. The nationwide classes sweep in thousands of former and current prisoners spread across 11 states and roughly 100 individual prisons and jails. This unprecedented nationwide class action fails both Article 3 standing requirement, which requires all class members have a concrete injury, and Rule 23, in particular, the ascertainability, commonality, and predominance requirements. First, the damages class seeks pain and suffering damages for thousands of former inmates and jailees who claim they were not screened for opioid use disorder or provided MOUD. But the class definition sweeps in untold numbers of class members who have no injury. The first group would be class members who suffered no constitutional violation because even though they were under an alleged policy, the failure to provide MOUD or to provide screening in their particular case was not deliberate indifference, was not a constitutional violation, but was negligence, or was the result of what the district court recognized could be benign reasons. For example, an inmate who was not provided MOUD may not have been a candidate because of prior diversion or concerns about diversion that the sheriff or warden had that prevented that person from receiving MOUD. The other class...
But couldn't these, and I know the hypotheticals you've given regarding the diversion, but wouldn't those be outliers?
I don't think so, Your Honor, and there's a couple of responses to that. First, I agree we don't know how many of the class members are uninjured, but that's the plaintiff's burden to demonstrate that they have satisfied the prerequisites of Rule 23, that they can satisfy the court's rigorous analysis that the class should be certified. But I think it's pretty reasonable to think that if you have a class of thousands of former inmates, a large number of them will have not suffered any concrete injury as a result of a allegedly unconstitutional policy.
Well, wait a second. Are you saying that these people would have gone through opiate withdrawal without any injury? Is that what you're saying?
No, Your Honor. Well, I guess I'm saying a couple of things. One, there has to be a constitutional injury. This is a deliberate indifference claim. So,
Well, and the injury, though, is they have to have an injury in fact. And the injury in fact of all the members of the class is that they had to go through opiate withdrawal without the treatment that they might have been entitled to. These people say there was a policy of essentially not making medically assisted opiate withdrawal available. And how can you say that someone went through opiate withdrawal without an injury? How can you say that?
So that's not what we're saying, Your Honor, and I want to address that.
Well, if that's the case, then there's an injury, isn't there?
Correct, for that particular inmate.
But what inmate is there not an inmate? Are you aware of people who were opiate addicts who stopped taking opium or opiates and did not have the problems of withdrawal?
Well, the class, so no, Your Honor.
Okay, so everybody in the class has that injury.
Well, the class is defined, so let's just take the screening, failure to screen.
Well, does everybody in the class have that injury of going through opiate withdrawal and having the pain and agony of that?
No, Your Honor, the answer is no.
Show me one inmate, show me one human in the history of the world that didn't go through opiate withdrawal without pain and suffering.
Well.
Go to the
I'm not
medical,
talking
I mean-
about- Yes, Your Honor, I'm not disagreeing with the fact that if you go through withdrawals, then that is the claimed injury here, and that is, as the evidence in this case confirms, that can be anything from severe to flu-like symptoms. What I'm saying is the class includes a failure to screen component. So that can be an inmate or detainee who appears at the jail, has no symptoms, has already gone through withdrawals before they ever get to the facility, but they still have an OUD diagnosis.
Well, do you have,
That,
in all, you got access to all your clients' records, did they identify anybody like that?
well, so again, at the
Which,
class certification-
tell me the name of the person they identified with that, who went through, did not have withdrawal.
So what I would point, Your Honor, to, I don't have a particular patient name
Okay.
in this case.
Thank
Well, I
you.
guess I would point to, actually the named plaintiff, Smith, who was only in jail for 9 days, who the evidence shows arrived on buprenorphine, or MOUD. The prison facility said it should be continued, but she was released within 9 days before she could ever start the treatment. There's no evidence as to that particular plaintiff about withdrawals. In fact, the evidence shows once she left the facility, she went straight back to the community provider and continued her MOUD.
So this
So I guess
is,
that's,
did you argue the issue of standing below?
we did, Your Honor. That was argued in our briefs, and it also was discussed significantly at the hearing on class certification. And in fact, the district court judge acknowledges the Article 3 issues and attempted to craft a more narrow definition based on those concerns. So I do want to try to answer Your Honor's question and then turn back to some of the other issues, because the failure to screen component in this class definition includes people who would have not been screened, but would have suffered no damages as a result of that. No withdrawal symptoms, none of that, Your Honor. So I think that's an issue. Of course, you do have, again, this is a constitutional claim. So it's a deliberate indifference standard, and the case law is clear in the Fourth Circuit and all circuits that injury in law is not injury in fact. So you have to prove a constitutional violation, deliberate indifference, that led to a concrete injury. And even taking the screening or the inmate who suffers withdrawals, we don't know whether that inmate, unless we go through many trials and conduct patient-specific inquiries, we don't know if that inmate suffered withdrawals because of deliberate indifference, which would be a constitutional violation, or negligence, which would not. And that's what makes these particular claims so unsuitable for class treatment.
Well, haven't they alleged malpractice essentially as an alternative theory?
No, Your Honor, this is purely a deliberate indifference constitutional.
So what you're suggesting is that there would need to be a determination of injury for each and every potential class member at the class certification stage, and that is not what our circuit precedent says. In fact, we say that question, the class can be certified, and that those are questions that remain for a later date.
Well, I think what the cases say, I would point to Alley versus Rocket Mortgage as one of the court's most recent opinions.
And Mr. Dees
that-
is a more recent opinion from this court in which that question is specifically left open, isn't it?
Well, the question of whether you have to resolve the standing issue at the Rule 23 stage, I agree with that, Your Honor. I think Alley does that. I think Freeman versus Progressive does that. But in any event, even if you're not traveling under Article 3, you still have the Rule 23b3 predominance and superiority issues in a backward-looking damages class. And so just taking 23B3 and the predominance inquiry, obviously, if you're aggregating thousands of what are essentially personal injury claims that I had pain and suffering as a result of withdrawals, like I was discussing with Judge Gidney, those are individual claims.
My understanding is that your friend on the other side is no longer pursuing the pain and suffering as a basis for damages. We can clarify that when we get to him, but if that's true, does your argument still hold?
So if that's true, I think there's a number of issues. And I recognize that in their appellate brief, the plaintiffs did attempt to disclaim pain and suffering damages and say they would present only their economist cost-benefit analysis. The first problem with that is not how Judge Chambers took this case and decided. And the second problem with that is if these three named plaintiffs are willing to wholly disclaim the pain and suffering damages that were pled and that have been the crux of their complaint up until this appeal, then there are serious adequacy and typicality issues in the case now.
Although it seems like what they're saying is your client made more money, by neglecting to provide this treatment to individuals who are addicted to opioids. Essentially, I think the claim is that your client let people suffer without treatment that was medically necessary in order to make a lot of money. That's the claim. And so wouldn't that be a common claim, and one that was every member of the alleged class suffered, and every member of the alleged class was not provided the treatment, and therefore your client essentially had an economic windfall on the basis of the failure to provide the treatment?
So, a couple of responses. I think that's the theme, that Wexford prioritized profits over treatment. The claim, of course, is a Section 1983 deliberate indifference claim, which is, if you read this court's cases, and particularly Price versus City of Charlotte, that's a species of tort claim that travels under 1983. And the question has always been, do the damages you're claiming align with your theory of liability? And that's true in the class action context as well. You can look at Comcast versus Maryland, the Supreme Court's decision from 2013. It says you cannot present a formulaic damages model that's wholly divorced from your theory of liability. That is not going to satisfy the rigorous analysis that has to be done under the predominance and superiority inquiry. So, if the plaintiffs, the three named plaintiffs who purport to represent thousands of former inmates, really aren't satisfied with whatever their portion of the cost-benefit damages would cash out at, that is a significant adequacy problem, because they're purporting to represent class members who claim serious withdrawal symptoms, who claim personal injuries, potentially serious medical complications as a result of the withdrawal. And I think Judge Chambers, I think the arguments in the district court would have been quite different if plaintiffs were disclaiming any pain and suffering damages, despite maintaining those since the complaint was filed in 2023. But
the district court judge didn't really reach that question, so wouldn't it be appropriate for us to allow the district court judge to reach that question in the first place regarding the damages calculation?
Well, I think if you were going to remand the case for consideration in light of if the concession is being accepted and the plaintiffs are stopped from ever seeking pain and suffering damages, yes, I think the district judge would need to consider that concession, and we on remand would have serious concerns about adequacy of three named plaintiffs who are willing to accept a formulaic cost-benefit analysis. And again, I don't even think that would survive Comcast, because what the plaintiffs are saying is What they have to say under 1983 is, I have a deliberate indifference claim. I was injured, I suffered personal injuries flowing from a particular policy or a particular enactment of that policy that caused me harm. The cost-benefit analysis that seeks to calculate what it would have cost or what it would cost to apply comprehensive MOUD across various facilities has nothing to do with my individual 1983 claims. So I think you run headlong into the Comcast dilemma that you can't just show up at class certification stage and come up with any old formulaic damages method that's detached from your theory of liability. But again, I guess what I would emphasize is the ascertainability issues, the predominance issues when you have a nationwide prisoner damages class, that all of whom have claims that they suffered a particular harm arising out of this policy. You've got to determine if that harm was deliberate indifference or negligence. You've got to determine if they actually suffered any harm. And then, unless we're traveling under the conceded damages model, you've still got to have many trials on the back end to determine what each inmate's personal injuries were. And just quickly about the injunctive relief claim, I think it has not just an ascertainability issue for the same reason that the definition includes inmates who, prior to arriving at facilities, had a OUD diagnosis. Well, that is, quote, at the time of intake is the phrase the class uses, the class definition uses. Well, that is necessarily backward-looking, well beyond any records that Wexford might have, and probably beyond any records that the plaintiffs might have. And then the second difficulty with the injunctive relief class is that under Walmart versus Dukes, you have to have the same injury, and there has to be a one-stroke remedy that the court could impose. Well, here, as we pointed out, the inmates in the injunctive relief class are spread across 100 individual jails and prisons, all of whom have differing local approaches, policies made by sheriffs, wardens, corrections officials about whether MOUD can be permitted in their particular facility, because this involves bringing controlled substances into a prison and treating patients with controlled substances. So naturally, as the testimony shows, there are security concerns. This isn't purely a medical context. And so,
Quick question,
yes,
how many hard no's that you get, because I know that's one of the arguments that you all have made, I think it's the damages and maybe your injunctive relief class, is that these policies are, that your policies are in response to the policies of these governmental entities, sheriffs or counties or cities. How many hard no's? Because it's my understanding that it's Wexford's position that that they understand that this is the standard of care. So how many hard no's are you getting from these governmental entities that they're not going to follow the standard of care in terms of the policies?
So Judge Benjamin, the one we emphasize is St. Clair County, Illinois, which is still a hard no. This has changed over time as the district court's opinion sort of walks through. Because of Wexford's promotion and recommendations to facilities, I think Kaylee Mattis, a Wexford representative, estimates that now about 87% today, 87% of the facilities permit some form of MOUD treatment. At one time, facilities, going back to 2022, a lot of the facilities were forced withdrawal only. They did not allow MOUD. Then from 22 to 24, we started having some facilities that permitted continuation. So if a patient arrived with a buprenorphine prescription, they could continue it, but they couldn't start MOUD in prison. And then today you have more doing comprehensive. So it's a shifting period. And I think today there's much less hard no's just because of Wexford's efforts and, of course, shifting views in the corrections community about MOUD and OUD.
All right, thank you. Judge
Thank you.
Bernard, Judge Gibney, do you all have any additional questions?
No, ma'am, thank you.
No, thank you.
All right, thank you, Mr. Bentley. Yes, sir, Mr. Forbes.
Good morning, Your Honors. May it please the court, Jesse Forbes on behalf of the plaintiffs' appellees, Lawrence Burlock and others similarly situated. As the courts recognized in the beginning of the argument, this is a class involving inmates and detainees, both pretrial and post-conviction, who were denied serious medical need treatment throughout Wexford's facilities. This is a private medical provider that takes hundreds of millions of dollars across the country, and as part of those contracts, indicates that they will provide constitutionally sufficient medical care. It has to meet the standard of care. It doesn't matter whether the person suffers from OUD, diabetes, a heart condition, whatever that is, when they take on that state duty, they have the duty to provide that medical care. And what they've done here, and they really don't challenge it, and never challenged it below, never challenged it with Judge Chambers, is that they acknowledge that these are serious medical conditions. They also acknowledge that they're not providing the treatment, the known standard of care. There's really been no challenge at all at this point that it is the standard of care. And I would point out,
What evidence do you have that Wexford treats all of the patients or inmates the same?
so, Your Honor, and that's exactly what we presented to Judge Chambers, and it's in the appendix and briefing. Throughout their own internal presentations, from the top all the way down, their internal presentations, they acknowledge that it's the standard of care. They acknowledge that the facilities, and we tailored this in the class certification petition, the facilities that are in there, they do not provide that standard of care. They utilize forced withdrawal. We had testimony on it and through all their documentation. It hasn't been challenged at all with respect to those facilities. And that's why this is a narrowly tailored class. The damages class did not cover all 100 facilities. There were some that prior to the date and time had started providing care. But these facilities, they did not provide that care. They chose not to provide that care. And this is much different from the Walmart case or others where you have a situation where they have a policy to actually provide it, and then they have individual, either managers or here, it would be health professionals, making some judgment call, whether it's good or bad, not to do it. This is an across-the-board policy, and that's what Judge Chambers found in a well-reasoned 37-page opinion. I mean, this is a case where we filed multiple definitions of what the class should look like. We had a lengthy hearing with Judge Chambers, and he ultimately and rightly rewrote the definition to make sure that ascertainability would not be an issue. And by doing that, by making this a tight definition, he has placed this where there is simply no question that the class members and the others similarly situated would be easily ascertainable, and that their issues would predominate. And I want to address the
But
damages argument.
I want to ask you a question about predominance while you're on predominance. What do we do with the fact that the facilities and the state laws have different policies, and that those policies might be at play and potentially defeat predominance?
Well, Your Honor, in order for that to be the case, there would have to be something in the record demonstrating that. As my friend was just asked about what facilities actually gave them a hard no, or any state laws where there was a hard no, they pointed to one, which when you actually go through the testimony, never gave them a formal hard no. It was they couldn't quite decide whether or not they were allowing it or not. So there isn't an institutional policy from the prisons, but even if there is, or from the state lawmakers or county lawmakers, even if there was, the fact that someone else is being constitutionally deficient does not absolve a private contractor who is promising through a contract to provide medical care to people that can't get it anywhere else. They can't walk out to a hospital, they can't walk out to a clinic. This is someone that is stuck there, dependent on these people for every level of health care. This is a serious medical need. So either way, they would be responsible for their own actions. But the other thing that in the context of jail and prison medical law, that what you see across the country, particularly with Wexford, is that their staff knows if they can't treat a condition at a facility, they are to send someone out for treatment. They do that at intake. They screen every single person that comes in. And if the person comes in and they screen with a heart condition or a certain type of condition that they're not medically capable of treating at the facility, they need to send them out for outside treatment. They didn't do any of that here. What they did instead was they understand it's a serious medical need, and then they force the people to suffer through the forced withdrawal.
So-
What about these hypotheticals that he's given regarding I guess, inmates or patients that are not, MOUD is not appropriate for? One of the hypotheticals is diversion. What's your response to those hypotheticals in terms of predominance? He's saying you're gonna have to have individual trials because you have all of these other situations where MOUD may not be appropriate. You may not give it to someone because of the diversion issues in being in a prison setting.
Thank you, Your Honor, and I appreciate that question. My friend here actually raised those exact same scenarios to Judge Chambers below. And what Judge Chambers did was take the initial definitions that we had started constructing, and he made it very clear in what he certified that you actually you screen for MOUD induction. And he addresses that in his opinion. He says he's not saying that the class necessarily, those people would receive MOUD. They need to be treated and assessed for MOUD induction. The policy across the board that was found by the district court that has lived and breathed with this case now for 2 years, the policy across the board was forced withdrawal, we don't screen them for MOUD, we don't consider it. There could be all sorts of medically important reasons not to place somebody on MOUD, and the district court recognized that in its order. But what it crafted the definition to include was that they need to be screened for that treatment. And that's what's vitally important is that they need to get the treatment that is the standard of care. This is a medical provider that promises to provide that care. You can't give deficient standard of care and meet the constitutional muster. And while I'm on this issue of predominance and the damages, I also want to point out, and rightly in the beginning of this, from Judge Gibney, he noticed and indicated that all of these people will be suffering from withdrawal symptoms, which is horrific. I mean, anyone that's looked at this or understands what opioid withdrawals are knows that these are horrible symptoms. They can actually trigger independent medical strokes and heart attacks and all sorts of cardiac arrest and different
And
conditions.
did you abandon the pain and suffering damages on appeal? Is that right?
What we've said on appeal on the pain and suffering damages, Your Honor, is that we are not going to pursue the individual pain and suffering damages on a class-wide basis.
Well, how can you then possibly represent all the people in the class? It seems to me that this business of how much money Wexford makes doesn't really have anything to do with how much the people suffered. I mean, Wexford could be, make billions of dollars from this, and nobody could suffer. It wouldn't make any difference.
There's a couple answers to that, Your Honor. First, this is a 1983 action for deliberate indifference. And as this court is well aware, there are potential damages, including the economic type of damages that our expert has laid out for the district court.
Well,
But you can
how is
also
that a
get
damage to,
nominal
how is that a damage to an inmate? The fact that Wexford makes money.
Well, what our expert has said is that they've actually deprived the inmate or detainee of that medical care, and it has an direct economic impact on their ability for recovery and their ability down the road. It's broader than just the money that they make if you actually look at his report, but that doesn't need to be reached yet, and that's what the district court said. The district court said that whatever damages are here as a result of depriving this are linked to the deprivation. The constitutional deprivation is complete when they do not screen them, and provide them the potential medical care. At
Well,
that
that's the
point, Constitution-
but, you know, it's like any other tort. You have to have a breach of duty, and you have to have damages.
And in the 1983 context, Your Honor, in addition to traditional economic damages or even personal injury, pain, and suffering damages, in 1983, it's black letter law for 50 years, I think at this point, there are potential nominal damages for a constitutional violation by itself, and there are potential punitive damages. And that was argued and raised in front of Judge Chambers at the hearing and in the briefing. And what he said is that he's looked at this in terms of what he needs to determine for predominance, but ultimately working through the class definitions, if the class is successful, there would be a damages model that the court would have to approve. And so I think it's early to look at the specific damages that are here, but whatever damages flow from the injury, flow from that injury, and the injury is complete at the time of this deprivation.
Are there,
So is it your, so it sounds like, but you would agree that Judge Chambers did not consider this economic damages theory of liability?
Well, I would not, Your Honor, because what he actually did, he had the expert's report, and the expert had differing categories of damages. And so while the expert did have a theory for pain and suffering damages, and these individuals could conceivably have pain and suffering damages on an individual basis, he said that he looked at the economic report, he looked at the expert testimony, and that he was satisfied that the predominance was there because whatever the damages were, which would be addressed later, at a later stage, whatever those were would flow from the concrete injury that's already occurred. So it's not, and what we've attempted to do by making this clear on appeal is negate this argument that there would be a slew of mini trials ultimately over what someone's injuries are. We never intended these to be medical malpractice cases. The other side has recognized that. They recognize that in the court below. They're not medical malpractice cases. They're not, I mean, there's potential wrongful death cases out there. We don't believe those would be subsumed into the class. What we have attempted to do is narrowly construct this class so that we can address economic damages, nominal damages, punitive damages that may be there without getting into this argument, which we don't agree with, about the mini trials, because we think there is a matrix there. But to make this a more uniform and simple class to deal with, on appeal, we made it clear that we do not intend to pursue the pain and suffering.
and so with respect,
I guess, go ahead, Judge Berner.
just with respect to your damages model, I've been trying to find other cases in the context of claims against healthcare providers that use this damages model in a class action case, and I was unable to find a case that did use this kind of damages model. Can you point us to any? Has a class been certified with this type of damages model?
I think what you have to look at, Your Honor, is that because ordinarily when you're in the context of a medical provider, you're looking at either some sort of product liability issue, or you're looking at a medical care itself issue, medical malpractice issues. Here, this is a 1983 claim, and so it really, what it runs through is the cases that involve awarding damages for solitary confinement or other constitutional deprivation. And that's what we've tried to maintain here is that it's akin to those types of cases where you actually have a constitutional deprivation. And, you know, I think if you look at the Eighth Circuit cases that are in the briefing, the Pistacco case, and others that are there, it's similar to that, and it's also similar on that stage. I mean, we are at class certification. I mean, even looking at Comcast, the district court doesn't have to decide what the damages are at class certification. It has to say they're aligned with whatever the injury was. The injury is complete at the time that this constitutionally deficient, deliberate indifference to a serious medical need takes place. And that takes place when they're not either continued on their prescribed medication or they're not screened for induction into MOUD. I mean, again, my friend never challenged and doesn't challenge, I don't believe here, that the appropriate standard of medical care for someone suffering from OUD in the way that it's defined here should be to provide MOUD screening and treatment. And that's exactly what we've asked for here. I do want to turn.
May I ask you a question about injunctive relief?
Yes.
How are you going to get past the Lyons case?
So, Your Honor, we believe that what we're asking for here is injunctive relief on a class-wide basis to essentially force this medical provider to provide constitutionally sufficient medical care. One thing I wanted to notice, or note here, is that one of the arguments that we've seen just for the first time on appeal, and they didn't place it in the district court where it would have been appropriate, is this argument about whether the representatives have standing in the injunctive relief class. First of all, these are extremely transient situations. You have inmates and detainees that are constantly going in and out of facilities, and the law has recognized that in those types of situations, you may not always have someone who's directly in a facility or in a place, and they could potentially be a class representative. But I would also note that with respect to Lauren Spurlock, she's been reincarcerated since the beginning of this case, faces potential reincarceration, and Sean Zudminski was actually, it's my understanding, reincarcerated just in October and is actually incarcerated again in New Mexico in what I understand to be a Wexford treated facility.
So
we
you
believe
think
on
that because
injunctive
these
relief-
people are addicted to opiates, it's unlike in the Lyons case where you'd have to show that the guy would get stopped again and choked again, it's likely that these people will wind up in the local correctional facilities where they reside and be suffered once again to go under Wexford's policy of no screening. Is that right?
That's correct, Your Honor. I mean, these folks are in the same communities where Wexford still provides the care. And I think what we've seen here, just in the pendency of this case, is that at least two of them have been reincarcerated. One's incarcerated right now, is my understanding, as we sit here. And we even checked his records yesterday to confirm he's still in a New Mexico facility that I believe to be Wexford treated. So, I mean, these are folks that are under either court supervision or potential probation or parole. They're also, to your point, in a community, in a situation where they continue to suffer the effects of the opioid epidemic, which, I mean, I'm from West Virginia. I know this court throughout this entire country, but particularly the area that the Fourth Circuit covers. This is the epicenter of the opioid epidemic. These folks are right in the middle of this.
These are all findings of fact, and as a court of review, it just strikes me that these findings of fact are more appropriately made. The jurisdictional discovery and the jurisdictional findings of fact on the standing issue are more appropriately made at the district court level. Isn't that right?
I absolutely agree, Your Honor, and they weren't raised there. I mean, that's
So,
the other issue.
but now standing's being raised, and it's a matter of jurisdiction and a threshold matter that needs to be confirmed, and so it strikes me that it would be appropriate for us to send this question at least back to the district court in the first instance to determine whether, in fact, with respect to the injunction class, there is adequate standing alleged.
And we understand, I mean, that's something that can be raised at any time, Your Honor. It's jurisdictional. So absolutely, the district court, I think, at any point is going to have to look at the standing issue. And so we understand that would be addressed, but the district court, from what the record is before Your Honors, had sufficient information at that time. And to Judge Gibney's point, I mean, these people are inherently, unfortunately, in situations where folks who are incarcerated come and go, and not at their own accord. I mean, there could be a court order that releases them one day. There could be a determination that they violate something and have to go back. They could be arrested, given just the nature of their substance use disorder. They could be arrested and go back. But what I want to make clear here, Your Honors, is that Wexford Health takes hundreds of millions of dollars across this country to stand in the shoes of the government. They haven't pointed, Judge Chambers, to any concrete government that says they can't meet the standard of care. And frankly, if a concrete government entity decided tomorrow that they can't use something derived from stem cells, or they decide that they can't use life supportive measures because of some political climate in a certain state, a medical provider cannot follow that. They have a duty at that point to say, we can't treat this person in this facility and send them out for appropriate treatment.
Can I ask you a question about your 23C4 proposal? You say that this could be certified as an issue class. I've never encountered one of those. So how would that work?
Your Honor, it's an alternative pleading in the event that the court would have concerns, which we don't believe there should be any concerns with the district court's ruling. It's an alternative pleading that would allow the district court to certify common issues amongst all the potential class members, as opposed to a full-blown damages class under 3.
So for instance, in this case then, what you would do would be attempt to prove that Wexford had a common policy that it applied across the country of not providing MOUD screening and as appropriate treatment. And then that policy violated either the 8th or 14th Amendment, depending on whether they were convicted or pretrial detainees. And then what would happen? Would those inmates have the right to bring suit on their behalf? And would that ruling be collateral estoppel on whether there is, in fact, a constitutional violation?
Your Honor, I think at that point, the district court would have to determine whether there's also common damage issues that could be certified. And so it could go in stages, and I've seen that before, where it could go in stages of, okay, let's certify an issues class, and then ultimately they could look at whether there's common damages. There could also be situations where, yes, there could be a finding that then could be used later in the individual damage classes if you got there. But you don't need to get there here because these are all common issues as the district court found. And so that's really just, and the district court, as we move forward, can make that determination. I mean, the district court can always redefine the class or determine decertify a class and decide there's an issues class later. All of those are avenues that are open to the district court, which it's already considered in a 37-page, well-thought-out opinion, way over time.
But then an inmate saying...
You can respond to Judge Gibney's question. Yes, sir. Judge Gibney, you have another question?
An inmate, say, in Martinsville could come in and say, well, I had to withdraw from opiates, and the policy that they used was unconstitutional. Therefore, all I should have to prove is my pain and suffering. Is that correct?
Well, I think that still gets into a factually determinate issue. I mean, it would have to show that it met the exact issue that was in the class. And then I think it would be up to the court that you're trying to say somehow there's, to your point, either collateral estoppel or some reliance on that prior opinion. I think ordinarily in the class context, we would have it as an issues class, and then ultimately the class members themselves would potentially be able to, either through damage categories that could be issue-driven or potentially through some other form of trial or finding, their damages could be looked at. If someone in some other facility that's not, that's across the country somewhere would attempt to use it, I think it would have to be looked at factually to ensure that it really, their situation meets directly with what the finding in this case would be.
Did you raise the C4 issue at the district court?
We did not generally
Okay.
raise that, Your Honor. I think we may have brought it up at one point in the argument as a potential alternative. I know that the court is extremely familiar with that as a potential there, and I think it was addressed, as I recall in the argument. I don't have that in front of me. But what we'd asked for there was the damages class itself, which the court, again, spent a lot of time going back and forth to make sure that the court was doing this in a way, and again, in a 37-page opinion, it was well thought out after a lot of briefing and a long hearing on this to determine that it was appropriate in the facts and circumstances of this case. We would ask that Your Honors deny this motion, remand this case back, allow Judge Chambers to continue the work that he has done for years on this case, and if the class ultimately needs revised, that is something that's available to the district court below.
Any other questions, Judge Barner, Judge Gibney?
No.
Thank you.
All right, thank you.
Thank you, Your Honors.
Yes? Yes, sir. Okay, Mr. Forbes, Mr. Bentley, you have some follow-up time, 4 minutes.
Thank you, Your Honor. Just a few quick points if I can. First, I do want to start with the damages model discussion because I think what plaintiffs are now proposing runs headlong into 1983 and the Comcast requirement under Rule 23. So I'll read from this court's opinion in Price versus City of Charlotte from 1996. The basic purpose of Section 1983 damages is to compensate persons for injuries that are caused by the deprivation of constitutional rights. And to receive compensatory damages, the plaintiff's damages must be grounded in determinations of plaintiff's actual losses. You combine that with Comcast, the Supreme Court's 2013 decision under Rule 23B, that says you cannot show up at the class certification stage and have a damages theory that is wholly detached from your theory of liability. So what plaintiffs are doing is contrary to both 1983 and Rule 23B3. I don't think they can just scrap the type of damages that traditionally are sought and were pleaded in this case. And if they are doing that, then as we discussed, these named plaintiffs have a severe or serious adequacy and typicality issue that the district judge never had the opportunity to address. Turning to the class standing, the overbroad class definitions, all of this was raised and discussed with Judge Chambers. The hearing transcript is in the record. Judge Chambers questions counsel significantly about the number of uninjured patients and inmates that would be swept into the class definitions and attempts to refine the class to address that very concern. His opinion also mentions it. So these issues were in the case. Now we think Judge Chambers couldn't revise this class because to meet the Rule 23B criteria, no matter how industrious he was and how hard he tried, because this is a conglomerate of personal injury claims at the end of the day. I do want to also note that there's been a lot of discussion by my friend about the standard of care. And we all agree that the standard of care is to provide MOUD, comprehensive MOUD. That's what Wexford has recommends. Plaintiffs use Wexford's own guidance. They don't have their own expert in this case. They use Wexford's guidance to show what the standard of care is. But that's completely different than the constitutional deliberate indifference standard. This court has said over and over again, just like the Supreme Court in all circuits, that medical malpractice, a breach of the standard of care, is not the equivalent of deliberate indifference. There has to be subjective recklessness. So all of these claims, simply deciding whether the policy is in line with the standard of care does not resolve the thousands of individual deliberate indifference claims, all of which depend on the inmate's individual experiences, the treatment he or she received, whether the treatment was simply negligent, which would not be a constitutional breach or rose to the level of deliberate indifference, and then if there were any harms at all.
Well, it's not subjective recklessness. In the case of an Eighth Amendment claim, it's subjective knowledge that there is a dangerous condition that will harm this person. The case of the 14th Amendment case, you got to have a reason to know. Isn't that right?
That's correct.
Okay.
Yes, thank you, Your Honor. I mean, the deliberate indifference standard in the 14th Amendment context is a new or should have known standard. It's not an actual knowledge and disregard standard. But in any event, there's still a recklessness component. It's not simply breach of the standard of care or negligence. Thank you, Your Honor.
All right, thank you. And of course, we can't step down and greet you, but I want to say thank you on behalf of myself and Judge Berner and Judge Gibney. And at this time, we will, I think, Judge Berner, Judge Gibney, do you need a break?
No, I think we can proceed to the third case.
It's fine with me.
Judge Gibney?
John, will you get me a water, please?
All right, thank
Off
you,
that.
Mr. All right, our third case is case number 25-1375, Jesse Neer versus Inerco Group, Inc. First, we will hear from Mr. Christopher Moore, and on behalf of appellant, and then we'll go to Mr. Edward Moore, third, and Mr. Schillings. All right, yes, sir, Mr. Moore.
Good morning, Your Honors. May it please the Court, my name is Chris Moore. I'm attorney here on behalf of the estate of Douglas Belger, the appellant today, and the plaintiff in the lower court below. Mr. Belger died in the hospital while receiving medical care for extensive burn injuries he sustained as a result of his clothing having ignited. The source of that clothing ignition was a propane tank top gas heater or space heater. It's essentially a heating element that screws onto the top of a 20-pound or propane gas tank, much like what most people associate with gas grills. It is lit with a flame source, turned on, and it heats things in that given area. Mr. Belger's estate brought a design defect claim under South Carolina law against the manufacturer of the propane gas tank top heater, which is Inerco, the appellee. The primary contention on appeal from the district court's order, which did a couple of things. First, it denied our request for the district court to certify a question to our state Supreme Court. That question was dispositive in the district court's order, and then her order also excluded our human factor warning experts' adequacy opinions and granted summary judgment on that ground. There was also a motion to exclude our engineering expert, and that motion was deemed mooted by the district court's decision on what I'm going to call the warnings trump design issue. The district court very clearly felt bound by this court's decision in the Hickerson versus Yamaha case. And that is the position that we primarily take issue with on this appeal.
Well,
So on the certification question, you base your claim on, I guess, Branham. You said Branham is more appropriate, but we have this Hickerson case that from the Fourth Circuit, but Branham predates Hickerson. Do you think that Hickerson is wrongly decided?
Yes, I do. As a matter of South Carolina state law. And here's why. It's a curious thing to me, I will be frank. Hickerson does not reference the Branham case, which, as long as I've been doing this in South Carolina, that is kind of the most recent big development in our product liability law. And the case finds, no reference in the text of Hickerson. I don't believe that the parties to the district court in Hickerson argued it. There was some passing reference to the Branham decision by the Appellee's Council at oral argument in Hickerson, but this issue just did not come up. In the oral argument at Hickerson before the Fourth Circuit, both Judges Agee and Judges Floyd said, why are you not asking us to certify this question to the South Carolina Supreme Court? We recognize that in the prior decisions of the lower intermediate courts, there is some discussion of this comment J in 402A. However, the South Carolina Supreme Court has never ruled that the lack of an inadequate product warning, the existence of an adequate product warning will always exclude a design defect claim. That has never been held by the South Carolina Supreme Court.
but didn't the legislature say something about that?
They did. In 1974, when our product liability statute was enacted, it adopted the comments and explicitly 402A. They call it the 402A Act in South Carolina. However, in Branham, in 2010, which postdates the 4 primary cases that the Fourth Circuit looked to in applying, because it had to, South Carolina, it was not asked to certify that question to the South Carolina Supreme Court. In looking, in Branham, what happened was the Supreme Court of South Carolina said, we are going to move away from 402A for purposes of design defect claims in South Carolina law. Up until that point, under South Carolina law, a design defect claim could be brought under 2 theories. The consumer expectations test, you could also bring it under the risk utility test, and there was certainly some reference in our precedents to that risk utility test. But a design defect claim could just as equally be brought under the consumer expectations test, which is comment G of 402A. And so what the Supreme Court did in Branham in August of 2010 is said, we are no longer going to accept consumer expectations in design defect cases. And we are going to look to the restatement 3rd, section 2B, and we hold that the risk utility test is now the exclusive test for design defect cases in South Carolina.
What do you make of though, but in Branham, they go back and cite that Supreme Court Claytor case?
Yes.
Which is cited in Hickerson, although Branham is not cited in Hickerson.
Yeah, that's correct. But I would submit that if you go back and you read Claytor is unremarkable and it simply says that if there is no proof of a design defect, if there is no proof of a manufacturing defect, and there is no inadequacy in the packaging of the product, then it cannot be held to be unreasonably dangerous. It does not say that a lack of a inadequate warning precludes a design defect claim in all circumstances under any product liability theory. There are admittedly the Allen case and the Anderson and then the Curcio case that pay reference to that, but I think if you go back and look, the Curcio case was actually reversed by our South Carolina Supreme Court on another issue. They said there was sufficient evidence of inadequacy of that warning such that the case was properly submitted to the jury, and they reinstated the jury's verdict on that issue. And because of the 2-issue rule that we have in South Carolina, there was no need for them to delve into the substance of that other opinion, which is that comment J, read literally, would seem to preclude a design defect case by the existence of an adequate warning. And so I think Branham is the key. Why the Hickerson court was not presented with that, I don't know, but admittedly, the Hickerson panel said, why haven't you asked us to certify this to the South Carolina Supreme Court? Because we clearly have no guidance from them. It's explicitly.
So on Branham, do you think the Supreme Court, the South Carolina Supreme Court, there adopted the 3rd reinstatement and entirely in its comment?
It explicitly adopted it for purposes of design defect cases. And so that is our explicit rule. We have to follow the 3rd restatement, section 2B, for design defect cases. And the comments inform that. If you look, and we've cited a number of cases in our brief, Judge, if you look at what our district courts, what our state courts have done post-Branham, it's replete with references to the restatement 3rd of section 2B. And if you look into the text of Branham, Chief Justice Kittredge is very careful to say, there's this prefatory statement before they announce their holding that says, we are mindful of what the legislator did 50 years ago in the statute. However, we also are mindful that they're looking to the American Law Institute, which does the restatement, and advances in our law. They would look approvingly on our moving away from 402A for design defect claims and adopting the rule of section 2B of the 3rd restatement of torts. And if you look in the comments of the 3rd restatement of torts, there are a number of references that would apply to a design defect claim, including that warnings are never a substitute for the provision of a reasonably safe design. Obviousness of risk does not necessarily obviate a duty to provide a safer design. Essentially, warnings, while good, and yes, there are some products that will require a warning in order to be made safe, that is not the end-all, be-all, and that you can still have a design defect claim. Around the same time, as your Honor is aware, that Branham came out, there was the Watson versus Ford decision in South Carolina that clearly delineated the three types of product defects, independent theories of relief that South Carolina courts recognize. There are design defect claims. There are manufacturing defect claims. There are warnings defect claims. And the district court in the Marshall case was presented with a similar, almost this exact same argument. It said, look, these are independent theories of relief. The notion that the lack of an adequate warning would somehow defeat an otherwise viable design claim is not the law. That would require every design defect claim to have as part of their burden of proof the absence of an adequate warning, but that's not really what that tests.
So you're aware that a panel of this court is not able to abrogate a decision of a prior panel's decision, and so following that rule, we would be bound by this court's decision in Hickerson. But this is an odd circumstance where we have, as you say, a state Supreme Court case that predates the panel case, which seems to go the other way. And so I guess I'm struggling if you're aware of a case that says that where there's in this type of circumstance where you have a state Supreme Court decision, the highest court of the state conflicts with a subsequently decided circuit authority interpreting the same question, that we're bound by the state Supreme Court decision and not by our own prior precedent.
So I'll be careful about that. I mean, I don't have a case that says, that you cannot abrogate Hickerson. What I would say is that we are asking you to certify the question under our Supreme Court Appellate Court Rule 244, and that you absolutely have the power to do that. You have the power to do that sua sponte, whether I even ask the court to do that or not, which we have. And the circumstances for when that is appropriate are that there is no controlling Supreme Court precedent, which there is not. There still is not. That was recognized by this court in Hickerson. And since that time, that has not changed. Hickerson has never been cited in any of our South Carolina appellate courts precedents.
But aren't you saying that Branham is in fact controlling?
Yes, Branham is controlling.
So there is controlling Supreme Court precedent from your state Supreme Court.
Branham is controlling as to design defect claims only, and that is how we brought this claim. This was not brought as a warnings defect claim. And the law in Branham is the...
I guess I'm struggling with this notion that we would certify a question to the state Supreme Court that the state Supreme Court has already answered.
Well, this question has not been answered, I'm sorry. The test for a design defect claim is what Branham has set forth. The question that we ask to have certified to our Supreme Court is, does the existence of an adequate warning preclude in all circumstances a design defect theory, which is essentially what's happening. That actually runs contrary to Branham. Branham doesn't say that. Branham says that in a design defect claim, you have to show that the product is reasonably dangerous and that that unreasonable danger can be remedied by a feasible alternative design, full stop. It doesn't say, oh, and you also have to show that the warnings given were inadequate. And that is the problem here, is that Hickerson looked to cases that predated Branham and does not discuss Branham. And there is still been, and what they said in Hickerson was that we've looked at the state Supreme Court precedents and there are none. And so all we have left to look at, because you haven't asked us to certify the question, are the intermediate appellate court's decisions. And there's 4 of those. Here's what they are. Here's what they say. Well, none of those cases have been cited in any of our state court decisions post-Branham. The only place you will find them for this proposition is in our district court, much like as in Hickerson. I would also say that the facts of this case, so our second point is that alternatively, the district court should be reversed for excluding totally our warnings, our human factors expert.
Well, if they're correct, if the judge is correct in excluding Dr. Gergel, Isn't your case pretty much dead in the water?
If the rule of Hickerson holds.
Well, yeah,
Well,
Hickerson is a problem for you.
absolutely. That's why we're asking you to send it to the Supreme
Yeah.
Court. Because it is
But getting back to the expert, if the expert's not allowed to testify, you just can't prevail in this case, can you?
oh, no, that's not true, because we're not trying to prove a warnings defect case. We're trying to prove a design. I see I'm out of time. May I finish my thought?
You can continue and answer.
So, and the problem with what the district court did here was the exclusion of Dr. Grugel, and the standard applied to her was that what you would apply to a warnings expert in the context of a warnings defect case. We were not alleging that the lack of a warning caused Mr. Belger's injury. We were very clear about that. We could not. Mr. Belger never got the owner's manual. This was not his product. He didn't purchase it. He never saw the packaging. And so this notion that we were advancing an alternative warning, that we needed to focus group and test and run through that rigmarole to see if it changed people's behaviors, in other words, was that warning causal to his injury, was not something that we could do. He never received any of the warnings with the product outside of what was stamped on the reflector shield of the, and so.
But did she base her decision on any studies or scientific basis besides her own personal opinion? I mean, district court judges have discretion on issues of expert witnesses, and it seems to me the district court reviewed the materials and said, this doesn't pass muster under Daubert.
Well, the criticism I have of that is that she said, well, there was no testing. She didn't look at photographs. She did not interview witnesses. Well, all of those things were unnecessary for what she was saying in this case, which is a more general opinion about what is the design hierarchy for an engineer, because we're looking at this as a design case. In other words, if you can design the hazard out, which we've demonstrated, you do that first. You don't rely on a product warning, because we all make mistakes.
Well, she's your product warning expert, right? She's not your design defect expert.
Well, she is a human factors expert and a warnings expert, but we were trying to use her in a way to say, when you're designing a product, here's what you look at. Here are what your options are.
But why was it an abuse of discretion? That's a pretty high standard for us to say it was an abuse of discretion.
It was an abuse of discretion because the standard that she held her to under 702 were from cases in which the warnings defect was what was being advanced as opposed to just a design defect. Her criticisms of, just the general idea that you would rely on a warning rather than actually just make a better guard were not something that the work that she did in the case I thought was sufficient to give those opinions. She also analyzed it with the relevant industry standards, the ANSI standards, as how you do warnings. For example, in the Hickerson case, the on-product warnings were pretty robust, and they were in 2 locations, and that was kind of the issue that the district court and the Fourth Circuit had there. And Mrs. Hickerson admitted, I didn't read them, and in hindsight, I probably wouldn't go back and read them, and it didn't change my behavior. And she violated all 4. She was on the jet ski in the inappropriate clothing with a 10-year-old driving under the influence of alcohol, and there was 4 people on it when there should only have been 3. So I'll sit down unless you have any other questions, and reserve 5 minutes for rebuttal.
Thank you. You have some time reserved, so we'll. All right, yes, sir. Mr. Moore.
May it please the court. Ray Moore from Columbia, South Carolina, Your Honor. Good to see you again. Members of the court, the trial court did not abuse its discretion in declining to certify a question to the South Carolina Supreme Court. The district court applied the correct legal standard, and the district court supplied substantial justification for her decision, most prominently this court's decision in Hickerson. The district court understood and applied the correct legal standard, both in her order and in the colloquy from the bench during the hearing, which is in the record. She understood that the question is, was South Carolina law clearly insufficient? And if only it's clearly insufficient, then the district court should have certified the issue. Secondly,
Let me ask you this, Mr. Moore, because so we have Hickerson, which is the Fourth Circuit case, and then we have we have all of these cases that the South Carolina Court of Appeals has cited. Then most of them, I think, predate Branham. And then we have Branham that cites Claytor. Branham seems to adopt some parts of the third reinstatement, at least the risk utility test. But then it cites Claytor, which Hickerson also cites, but
Right.
Hickerson doesn't discuss Branham. Why isn't this appropriate to send to the South Carolina Supreme Court
so,
to give us some direction, a final answer as to this question?
sure, both the district court, Judge Childs at the time, and this court had the benefit of Branham. Branham doesn't speak to comment L of the third restatement. Branham, and my colleague, Mr. Moore, the other Mr. Moore, took pains to say that Justice Kittredge took pains to adopt the restatement third. But if you read the court opinion, the court was well on its way in Branham to the reasonable alternative design standard, and it used the third restatement as an additional ground. The words that Justice Kittredge used there were, this approach is in accord with the third restatement. It wasn't adopted. It was, at most, I would say, cited approvingly. So then, what has the Supreme Court done with 402A? That's the law. That's what the General Assembly enacted back in 1974. What has our Supreme Court done with that? Well, we still look to the comments of 402A. If you look at the Lawing versus Univore, I believe it is, this is a sodium bromate explosion case. It's a warnings case. And the Supreme Court, in that case, 5 justices of our Supreme Court issued 3 separate opinions. Both the opinion of the court, the concurring opinion, and the dissent all relied on 402A comments to define what a user is under 402A. So we're still applying the comments of 402A in South Carolina. The question has been asked, why didn't the Hickerson court, either the district court, Judge Childs, or this court, why didn't this court rely on Branham? Because Branham doesn't speak to comment J. Branham doesn't change the law. Branham just clarified an issue of South Carolina law. Was the reasonable alternative design required, or do we just apply the consumer expectations test? And the trial court problem in Branham was they tried to use both. That was the conflicting issue going on. We had a line of cases. Claytor is one of them. Bragg versus High Ranger, where the courts were applying the risk utility test and requiring, or at least referencing, a reasonable alternative design. But the court in Branham just clarified, without adopting the restatement third, that that's the way the law was moving. There was no discussion of comment J, and it's really inconsistent. The rest of Branham is inconsistent with the plaintiff's position. This design hierarchy that is a platitudinous idea that engineers may be taught, but it is simply not the law. And the Branham court, Branham is a wide-ranging opinion in product liability law in South Carolina. My colleague, Mr. Morris, is very correct about it. It does touch on a lot of issues. Other similar incidents is one of them. But within the discussion in Branham on the reasonable alternative design, the court took pains and said, we do not suggest a jury issue is created merely because a product can be made safer. That's the argument of the design hierarchy that plaintiffs posit here. We adhere to our longstanding approval of the principle that a product is not in a defective condition, unreasonably dangerous, merely because it can be made more safe. And that's the position of plaintiffs here. This design hierarchy is you don't have to put a warning on it if you can just put a larger guard. If you can do this or that, you can design out a hazard, then the product can be made more safe. And that's not the law in South Carolina. From well before the restatement was adopted through the restatement, there are cases after case that suggest a product is not defective because it can be made more safe. In one meaningful case involving a crane tube blocking accident, the Marchant case, the court analogized to a bicycle with a bell. You don't have to put a bell on a bicycle. At the time, you don't have to put disc brakes on a car or a steel belt in your tire. Those are potential ways a product could be made more safe, but it's not required under South Carolina law, and Branham did not change that. Branham left that principle in place. And that's why the court in Hickerson didn't need to reference Branham, but my colleague is wrong about the fact that Branham was brought to the court's attention in Hickerson. I was surprised to read at page 6 of the reply memo that Branham was not argued to this court, but in fact it was. The briefs are publicly available, pages 20 to 22 of the appellant's briefs in Branham argue vociferously. It was happened to be my torts professor, Professor David Owen, who was appellant's counsel there. And just the very summary of the argument, reading from the brief, by adopting Section 2B of the third restatement in Branham, the South Carolina Supreme Court implicitly adopted its explanatory comments, including comment L. That was not accepted by this court in Hickerson. The court didn't even see fit to respond to that in the opinion, but the opinion did address the other arguments made, such as the public policy argument that my friend has made in his papers. So Branham does not need to be referenced in Hickerson. Branham doesn't change the law. The law is, as the lower court found, based on the restatement, as Your Honor mentioned, our General Assembly has spoken to the issue. The second thing is our intermediate courts have spoken to the issue, and my friend again suggests that our Supreme Court hasn't spoken, but I would posit to this court that our Supreme Court has spoken implicitly, because 3 of these cases, Allen v. Long, Anderson versus Green Bull, and Curcio, all went up to the Supreme Court. Twice cert was denied. Our Supreme Court left in place this language from comment J and the interpretation and application of comment J in both of those cases. More telling, in Curcio, the case went up and the court reversed it without touching comment J, left it absolutely in place. And irony of ironies, the trial court in the Curcio case was presented the restatement third argument. If you read the Court of Appeals opinion in Curcio, the trial judge is quoted, and the trial judge says, plaintiff urges adoption of restatement third of torts. This is 3 years after the promulgation of the restatement third, and it's already been presented for the first time to our courts. Plaintiff urges adoption of restatement third of torts, which allows recovery based on defective design, even with an adequate warning. Defendant has demanded adherence to existing South Carolina law. This court declines plaintiff's invitation. The language in Allen v. Long is clear. That was the trial court in 2001. That trial judge was none other than John Kittredge, who sits currently as the Chief Justice of our Supreme Court and the author of the Branham decision. And in Branham, as I've already told you, he specifically adhered to the issue that a product is not defective simply because it can be made more safe. The restatement third issue has been argued repeatedly and shot down. This is not new. This is not novel. It was shot down in Curcio. It's obviously been shot down in Hickerson by both Judge Childs and this court. It was made to Judge Houck, the late Judge Houck, in the Aldana case cited in Hickerson in 2008, and he rejected it. It was made to Judge Childs again after Hickerson in 2021 in the Grubbs versus Walmart case. I apologize, I was not looking at the clock, and I see that I'm out of time.
Thank you.
My colleague, Mr. Schillings, will address the second issue. Thank you.
Thank you.
May it please the court, my name is Scott Schillings. I'm from Wichita, Kansas, so I'm a visitor to the Fourth Circuit for the first time. I appreciate you allowing us to split our time. I did not want to walk into the buzzsaw that is this apparent argument about South Carolina laws. I'm not a South Carolina lawyer. What I am is a longtime lawyer handling product liabilities across the country, product liability cases such as this. And I want to point out a couple of things that Mr. Moore said. There wasn't much time spent on this side of the argument, which is whether or not the court abused its discretion in striking the opinions of Dr. Grugel. And also, we also believe that the summary judgment could be affirmed on the grounds that had the issue of Dr. Rondinon's methodology been taken up, that he similar would have been stricken for not following any methodology in making his determination or not making a determination as to the cause and origin of the fire, where it started, how it started with Mr. Belger. First thing I want to point out that Mr. Moore said is he says, well, this is a space heater. It's not a space heater. There are several different types of heaters that are manufactured, and they serve different purposes, and they're certified to different standards. This is an outside radiant heater. It works in the infrared. It produces a hot red surface that radiates heat to heat objects. Unlike a space heater, which provides convective heat to heat air. If you're outside, convective heat does not work very well, because if there's wind, if there's rain, it's not felt. So this heater, and there's pictures of it in the briefing, glows orange and burns bright, and so that needs to be understood. Now, what happened here was, in addition to the Hickerson issue, Dr. Grugel was stricken because she didn't follow any appropriate methodology in reaching her opinions, which were just, I guess now they're not warnings opinions, although she was referenced as a warnings expert 3 times in her report. Which
Well,
he's
she
now.
never saw one of these devices, did she?
She never saw one. She's never handled one. She's never used one. She spends 6 months a year in Hawaii. She's never interacted with one to see the heat that comes off it, to feel the heat that comes off it. Her experience with the heater was she watched 5 to 15 minutes of a video shown to her by Dr. Rondinon, and part of that video was his alternative design that was put on another heater not even manufactured by my client. So now, another question that came up, and one of the things that I want the court to be mindful of is Mr. Moore wants to say that Hickerson was decided wrongly, but Hickerson also struck the opinions of the warnings expert because of a lack of methodology. And if you look and compare what Dr. Cascobar did in the Hickerson case, where he actually came up with other warnings, tried to change colors, say these are the things that would have prevented this incident where 4 people were riding on a personal watercraft, that wasn't enough. The Hickerson court said your methodology didn't satisfy, and if you compare what Dr. Cascobar did to what Dr. Grugel didn't do, there's no comparison. Furthermore, in the Sardi case, which is also Fourth Circuit controlling authority, Sardi, 2 years before the amendments to Rule 702 were passed, is holding that no longer can it just go to the weight of the evidence, the questions about what you did, whether or not you followed the appropriate methodology, whether you needed to see the heater or not. Now the court has to look, with the admissibility of expert testimony, has to look at it and feel that by a preponderance of the evidence, that expert would satisfy the reliability requirements set forth in Rule 702. So the whole nature of the game that started with Daubert and to Joyner and to Kumo, and for years courts have saying, oh, it goes to the weight, not the admissibility, has changed. So I don't think there's any doubt that Grugel did not follow a necessary methodology, and of course the standard is abuse of discretion. Judge Leiden at the lower court spent 9 pages outlining everything she did or didn't do. It cannot be said that she abused her discretion. What I want to do really quickly is flip then to what I think the alternative argument is here, is that if Judge Leiden had not rendered moot the Dr. Rondinon analysis, Dr. Rondinon would suffer from the same lack of methodology, and thus this court can uphold the lower court summary judgment on a total another ground outside of the arguments that are being made about the importance of Hickerson and what the status of South Carolina law is. Dr. Rondinon admittedly did not perform any 921 analysis on the injuries to Mr. Belger. He never looked at the medical records, which showed that the primary burns suffered by Mr. Belger were on the lower backside of his thighs, an area well below where he believes, or surmised, he didn't do any testing on it, that the coat may have caught fire while being at the top of the heater. Without doing any 921 analysis, which is, of course, what is recognized as the methodology for fire cause and origin, he then just proceeded to construct a heater that he says would have prevented this incident without doing any testing to see if that actually made the product more safe or reasonably safe.
But the district court didn't do any of this analysis with respect to the Dr. Rondinon.
That's correct. And the reason why I'm bringing it up is because when I got the verdict, when I saw the order, I was disappointed. We won at the lower court, but I thought with regard to these 2 experts, their complete lack of appropriate methodology should have barred both. The decision should have been in this court. Go ahead, I'm sorry.
The district court never exercised its discretion, never reviewed those, really simply found it was not relevant after finding that Hickerson was binding. And so if we were to either disagree or the South Carolina Supreme Court were to disagree and say that the 3rd restatement is in fact the law, then wouldn't the appropriate next step be for us to remand for the district court to analyze and make that determination in the first instance as the district court judge?
It certainly would be acceptable to do that. What I'm saying is that since this court can validate the lower court opinion on any basis, that there's a record before this court by which you could uphold the lower court's decision based upon a finding also that neither of the experts satisfied the methodology necessary for under 702 as amended in 2023. And so, and that's, I think that's important, because what's happened in this case is what we had initially as someone who was a human factors expert is now this court is being asked to find that individual is actually a design expert, although she's never designed a heater and there's no qualifications for that. And then secondly, with regard to Mr. Rondinon, or Dr. Rondinon, they never responded to the arguments that we said that this court could have similarly stricken Dr. Rondinon. They simply said, well, that's not appropriate. It should be a cross appeal, which is not correct because we're not asking for anything to be changed. And then number 2, I apologize, dry mouth. But so they, and then what they did was they never responded to it and said, well, we actually identified somebody in a total another case that we could use him too. So they kind of abandoned Rondinon also. So,
Well, but I think the point is that the district judge never really.
the district court could not. We just asked that this court, or state that this court could also find that the summary judgment was appropriate on the grounds that neither of the experts satisfied the admissibility standards of Daubert, its successor cases, and the modified or amended Rule 702. Thank you.
Thank you.
Thank you. All right, Mr. Moore.
Thank you, Your Honor. A couple points real quick. If my friend was disappointed with the ultimate outcome in the district district court's order, it could have filed a Rule 59E motion on the subject of the mooting of the motion regarding our liability engineering expert. We've cited the American roll-on and roll-off case, I think the Henrico County School Board case from the Fourth Circuit, that say even the successful litigant below, if they are seeking to modify the district court's order, they must cross-appeal in order to do that. And here, because there's...
Excuse me, could you turn the timer on? Thank you.
And here, because essentially what they're asking the court to do is relitigate this other motion that the district court denied, I think it requires a cross-appeal. One case that we haven't talked about is the Miles versus Dessa case, and I think this exemplifies kind of the problem that we have here and the lack of clarity that we have here. So the Miles case is also a case by Judge Childs, the district court in Hickerson. It is almost the exact same product as what we have here. It is a propane tank top heater, and the plaintiffs in that case brought warnings defect claims and design defect claims under South Carolina law. Judge Childs said there is no warnings defect claim because you don't have to warn of something when it is an obvious danger. And that is something that my friends have argued throughout the case when it was in the district court. But they have set forth proof of an alternative feasible design, and that case can go to the jury, which is totally inconsistent with the rule of Hickerson. And it is post-Branham, and it is yet another example of why there is some confusion in this area, even post-Branham. The notion that the Supreme Court in Branham did not adopt the restatement of third for design defect claim, we simply disagree. There have been a number of cases since then, both from our appellate courts and the district court. We've put them in our brief that cite approvingly to the third restatement's comments, particularly for design and warnings issues. The Quinton versus...
Opposing counsel says 402A is also cited.
In the Branham case?
No, has subsequently been cited, 402A.
They
In other cases by the Supreme Court.
Yeah, the one case he's talking about, one of the comments was used to define what a user is, because that had never been defined before in any of our precedents. It was not a case involving whether or not a warning trumps design. There is Judge Childs, again, in the Quinton case from 2013, said it is clear that the Supreme Court in Branham adopted clear approval of the restatement third of torts, section 2B, and then cites to their comments in analyzing a design defect claim. The last thing I wanted to mention that I hadn't yet is that our district court for this case, in the Gardner v. Ethicon case that we cite, points out, and this goes to the criticism that a warnings expert essentially is offering a design opinion. That's not what we're doing. We're just talking about how manufacturers design things in this design hierarchy. Our jury charge in South Carolina and Judge Leiden in the Gardner case both recognize that the existence of warnings is a factor to be considered, that a jury can consider in a design defect case. In other words, is the warning given sufficient in a design defect case? They would still have the ability to make that argument before a jury, which is why we proffered Judge Grugel in the first place. This was always a design defect case. This was never a causal warnings defect case. It is an important matter of South Carolina state policy. There is confusion both in our district courts. The Branham case and its adoption of the third restatement
Well, and let me ask you one last question about that, because opposing counsel argues that that the Supreme Court did not adopt, that they basically just use it for support in their holding. And I'm just curious to hear your response.
I do not think that is the way that it has been perceived by the court since that time. In most of the cases that have noted this, albeit a lot of district court cases, and we've cited them in our brief, except the fact that our Supreme Court adopted the restatement third, section 2B for design defect claims in South Carolina. And I don't know how, if that is the rule that we have to prove in South Carolina, if that is our standard, then how can we ignore the comments to that section in favor of the comments of a predecessor section? And because our Supreme Court has never been addressed with this specific issue, whether the existence of an adequate design trumps all design defect claims in South Carolina, is simply one that they haven't answered and that we would ask this court to certify. Thank you.
Thank you. All right, thank you. We are going to, we're going to recess court for today, but before we recess, I do want to thank you all again, and we will have Judge Berner and Judge Gibney step down to greet you, and I apologize that I am not there, but the weather prohibited me from getting to Richmond last evening, and so I greet you from Columbia, but we'll have Judge Berner and Judge Gibney step down and greet you, and court is in recess. Thank you.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.